Details on the meaning of this ruling. We're now joined on the line from Pretoria by National Prosecuting Authority spokesperson Nathi Mncube. Thank you for joining us, Mr. Mncube.
Thank you, and good evening to you, and good evening to the viewers.
Now, prosecutors can appeal against the culpable homicide conviction. What exactly does this mean?
Well, what it means is that we are going to have an opportunity to try and convince the Supreme Court of Appeal that there was an error in law made by the court when it convicted Mr. Pistorius on a charge of culpable homicide. We will argue that, as we have already indicated during the application for leave to appeal, that there are issues that we are of the view that the court did not take into consideration, in actual fact applied the law incorrectly. Where we would therefore want to have the matter heard by the Supreme Court of Appeal, and to have the Supreme Court of Appeal clarifying those legal issues that we have raised during the during the application for leave to appeal.
Now, the state had also applied for the review of the sentence and the acquittal on the unlawful possession of ammunition. You must be disappointed that this didn't go your way.
Look, we were disappointed, but in the main, we actually wanted to be granted a leave to appeal in respect of the culpable homicide charge, because that was the main charge. But on the issue of law, also with regards to the possession of ammunition, it is important to have the matter taken forward so that it can also be clarified, because our view is that, failing to convict Mr. Pistorius on the basis of the argument, or rather the reasons that were advanced by the court, we are of the view that a different court might come to a very different conclusion, especially on the basis of law, and we are thinking that perhaps we need to consider petitioning the Supreme Court of Appeal in that respect too.
Now, in the meantime, what will happen to Oscar Pistorius? Is he going to remain in jail?
Well, yeah, the sentence and the conviction has not been set aside. What happened today is that we were just granted if I may use the layman's term, we were granted the permission to approach the Supreme Court of Appeal with a view to have the court listen to our arguments. And of course, the defense will also be invited to present their arguments and argue before, different judges and see if indeed we'll be able to be successful with that application to convince them to find or rather to come to a different conclusion. So that is what it means. But perhaps I can take this opportunity to also just a little bit indicate what the process is going to be. Right now, we need to file our papers. We are trying to establish from the registrar at the Supreme Court of Appeal how many days we have for us to file these papers. Once we have done so, we will then be given a date upon which we'll have to go to the Supreme Court of Appeal to then, present our arguments, both parties in actual fact. And from there on, then we will then wait for the court to deliver judgment.
Now, just finally, Mr. Mncube, when is the whole process expected to conclude?
Well, that is entirely up to the Supreme Court of Appeal. Ours really is, as I said, we're going to have to approach them and find first how much time do we have for us to file our papers. And once we have done that, we will then wait for them to give us a date, date when we then have to go and argue. They will also then give us another date when the judgment will be delivered. But it is expected that it should at the very least take at least 12 months. If one has to, look at the experience that we've had in respect of other cases.
Thank you very much for your time, Mr. Mncube.
Thank you so much.